Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Not every ex parte contact between a judge and a lawyer is necessarily something that needs to be reported. For example, when you catch the judge in the hallway and say, "Judge, I really need to set up a time to hear a motion in the Jones case," that may very well be ex parte, but it isn't about the substance of the case. It's about getting something set up, and the judge probably said, "Well, go see my secretary or go see the clerk or whatever it is," and you get that taken care of. That, even though that's an ex parte, I mean, that's a rule the judge can ignore, in that respect, because we're not talking about anything important here. We're talking about getting a date to hold a hearing and decide a motion. And as long as you don't mention anything about what the motion's about or why you think you ought to win, it's not an ex parte contact. It's simply a scheduling contact. So there are ex parte things that lawyers can do with the judge that don't violate any rules. And sometimes in jurisdictions where judges have to run for office, it's perfectly okay if outside of court you go to the judge and you say, "Judge, I want to support you for your reelection. Here's a campaign check for $500. Let me know if you need more." And as long as you don't mention any of your cases, there's absolutely nothing wrong with that. Again, as long as you're staying within the limits for, campaign contributions in that particular state. But there's nothing wrong with that because the judge is going to have to fund his campaign somehow, and he relies on supporters to do that. And most good lawyers will donate to both sides of a campaign because the risk is simply too great if you've only supported one. So it's not like you're really currying favor here. You're just really buying insurance against somebody being chipped off at you because you didn't support them. And a lot of lawyers play that game. They, offer judges money during their reelection campaigns. That's completely legitimate. But in this YSL case, that is not what we're talking about. We're talking about a substantive discussion about a witness who's already been sworn, and the judge is meeting privately with the prosecutor, the witness, and the witness's counsel in chambers without notifying the other defendant's counsel. Now, somebody has suggested, well, what if the guy is afraid of, being killed in a drive-by shooting because he's snitching on the other folks, and as a result, he doesn't want those other lawyers in there? Doesn't matter. And the reason it doesn't matter is because the lawyers themselves don't have to tell their clients what the subject of that meeting was. There are things that you can withhold from a client if you are under seal, if it's placed under seal or the court has advised you that it's not to be discussed with your clients, especially if there's some worry about somebody, perhaps being harmed as a result of something that you might disclose. So as a lawyer, you're an officer of the court, you have to obey that order. No question about that. The rules of judicial conduct and the case law all say you can't do this. So the question arises as to why the judge A thought he could do this and B thought he could put the genie back in the bottle by finding out who leaked it to attorney Brian Steele. I don't have the answers to those questions, but I can tell you this much. It's going to be a problem for Judge Glanville. And I really kind of liked this guy for the most part during the trial. I thought he was a very efficient judge. I don't routinely agree with his rulings. I think some of his rulings tended to favor the prosecution way too much. But again, judges are entitled to have some discretion in their rulings. And who am I to say whether or not he was abusing his discretion? That's for an appellate court later on. I think he gave them a little bit more leeway than he probably should have, but I don't really think that he is necessarily stretching things too far for the defense. Although this particular episode here where he had this ex parte meeting, that goes above and beyond, and that is clear favoritism toward the prosecution in this case, and that I don't think we can tolerate. So the reason I say I don't think you can tolerate that is because of how the Georgia Supreme Court acted. When Colette Resnick Steele filed the notice of appeal, she filed it in the Georgia Court of Appeals. And when you have a case like this that is very high profile, a lot of times there are back channel communications that occur that don't get disclosed to the public. I mean, it's just a fact of the matter. I'm sure that the Court of Appeals in Georgia, no doubt, had a conversation with the court in the Supreme Court of Georgia about this particular case. And they said, we got this appeal. Do you want us to handle it? And the Supreme Court said, no, that's in our appellate jurisdiction. It's our exclusive appellate jurisdiction. So they were aware of this. Clearly, they saw the news. I mean, judges do what most people do in the evening. They watch television, they read, they hear things, they talk to their friends. And this has been a topic of great concern over the last couple of days in the Atlanta area. So the Honorable Supreme Court of Georgia is in adjournment. But given the fact that they were in adjournment, they issued the following order. This is the following order that was passed. In re Brian Steele. Movement Brian Steele appealed to the Court of Appeals a trial court's order holding him in criminal contempt. At the same time, he filed in the Court of Appeals an emergency motion for supersedis bond on the criminal contempt. The Court of Appeals transferred that emergency motion to this court, citing State v. Murray, and noting that we have the ultimate responsibility for determining whether this court has appellate jurisdiction over the matter. The Supreme Court then goes on to say, we hereby grant a writ of certiorari as to both the emergency motion and the appeal of the contempt order, and they cite the Constitution. When the appeal of the contempt order is docketed in the Court of Appeals, the Court of Appeals is directed to transfer that appeal and record to this court. We further grant supersedis with respect to the trial court's order holding Steele in contempt. Now, what this means is he posts a supersedis bond, usually some minimal amount, $500, $1,000, and he doesn't have to go to jail. And then it goes on to say, as a result, enforcement of the trial court's order is stayed pending resolution of the appeal. So the order sentencing him to 20 days in jail or 10 weekends in jail is on stay. That means it won't be enforced until after the Supreme Court decides the appeal, and it would only be enforced then if the Georgia Supreme Court ruled against Brian Steele, which I don't really look for them to do. Now, why is this bad for Judge Glanville? The Georgia Supreme Court is not going to cheer on Judge Glanville's actions here. They can't allow judges to have ex parte meetings with prosecutors and ignore the defense and cut them out of those meetings because that's a denial of due process. Even if the Georgia Supreme Court allowed it, the United States Supreme Court clearly would not. I don't look for this to be something that they would routinely say, well, yeah, Judge Glanville has a right to know this. It's okay for him to hold this man in contempt. And the reason they wouldn't do that is because to get there, they would have to come up with some rationale for why it was okay for him to have the ex parte meeting in the first place, which again, I don't think they can do. Clearly, if they thought that the appeal did not have merit, they would not have acted on the emergency motion. They would have allowed things to go forward, and they would not have stayed the underlying contempt citation. But they did stay it, and I think that bodes ill for Judge Glanville. This was really not well thought out by the judge. When Brian Steele raised this, the first thing he should have done is he should have said, you're right, I should have called you all back in there. I'm sorry for not doing it. Here's what we discussed, or come back into my chambers. We're going to put this conversation on the record. You're going to be sworn to secrecy. You can't tell your clients, if that's what they were worried about. But as it is, it looks as though the judge is working for the state on the prosecution, and you can't have that. So it'll be interesting to see what the Georgia Supreme Court does with this. My guess is they will either declare a mistrial, or they will suggest very strongly that the trial court declare a mistrial, or they will simply vacate the contempt and remand it back to the trial court with instructions that the attorney-client privilege should be honored in this respect. Now, in addition to asking Brian Steele where he got the information, he has essentially subpoenaed all of the people who were in that meeting to come forward and say, basically ask them under oath, did you violate the seal of the court? Which, of course, there wasn't a seal of the court at that point, but that's what he's going to do. And if he does that, I would anticipate that several of them will also will also refuse to comply with the subpoena because the request is for attorney-client privilege or some other reason. We'll have to see. I think the judge could probably find a way to get the information if he wanted, but him wanting the information is a real problem because it indicates that the reason he wants it is to allow him to do this again in the future. You don't worry about who blew the whistle if you're never going to do this again, right? You worry about who blew the whistle only if you want to completely shut off that source of information to the defense team. And clearly this is not a source of information that should be cut off from the defense team. So that's what I have for you. Sorry I couldn't get to this yesterday. I had to go down to Mobile, Alabama and have my retina examined by my retina specialist, a lovely woman who I really enjoy meeting with her. She does a great job. I don't really enjoy having my eyes dilated or, that 30,000 kilowatt searchlight shined into my eye, giving me a sunburn on the back of my brain. But, you got to do what you got to do if you have problems with your eyes. So at any rate, thank you very much for watching. If you have the opportunity today, do something kind for someone. And then at the end of the day, you're more than welcome to come back here tomorrow and we'll talk about something else interesting, useful, fun, who knows. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.